originally. So we put her on a full and complete, the enhanced.
Before we do that, or contact person.
I concur. You can see by her demeanor in court today, she is independent, strong-willed, and a little bit feisty.
Welcome to Bench Report Court Cam.
Let me know when you're ready, Nancy.
I am all set. Thank you, sir.
All right, folks, we are back on the record now for the 28th Circuit Court. And this time we're going to take up the case of People of the State of Michigan versus Zoe, Arizona Davidson, file 24-13743FH. Appearances from counsel.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Davidson. She appears by Zoom.
Ms. Davidson joins us again via Zoom from the Washington County Jail. Ms. Davidson, are you able to see and hear me?
Yes, sir.
Thank you. Also here before the court today is Mr. Brian Potter, the probation officer on this file. We are here today for an informal hearing on a request and warrant for a probation violation that was placed in the file and signed by the court and the probation officer on October 17th. And then we had an arraignment on that same date. Mr. Harrison was appointed per request of the defendant. And so we're here. Mr. Harrison, why don't you tell me what we are doing today, sir?
Your Honor, we've reached it's not really a pretrial agreement. We've reached an agreement with the prosecutor for the resolution of this matter. I'll defer to Mr. Carnes. He wrote it down.
Your Honor, it's my understanding that Ms. Davidson will admit responsibility to counts 2 and 3 of that probation violation, and the people will dismiss count 1.
Mr. Harrison, does that sound accurate?
It does sound accurate. Yeah.
Ms. Davidson, have you heard them tell me what you're doing?
Yes, Your Honor.
Is that how you wish to resolve it?
Yes, Your Honor.
Please raise your right hand. You swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, Your Honor.
Lower your hand. Ms. Davidson, as we discussed last week, you are currently charged on this request and warrant for a probation violation with 3 counts. Count 1 is an allegation that you violated the condition to not use controlled substances based upon a report that you allegedly tested positive on October 17th for amphetamines. That charge will be dismissed. Count 2 is that you maintain some kind of association with a felon, and then allegedly on October 17th of this year, you had contact with a felon named Anthony Couch, who was at that time currently a parole absconder. I'm told you're going to plead guilty to that count, which is a technical violation. Count 3 is that you failed to follow an amended order, which required you to complete residential treatment, and allegedly you failed to complete that treatment successfully after having been discharged on or about October 16th, and that program was at Sacred Heart. That is a non-technical violation.
Your Honor.
Yes, ma'am.
So I did not just leave treatment on my own or get kicked out in any way, shape, or form. I was given a COVID test and I was tested positive, as well as coming to Wexford County Jail. They tested me as well for COVID and I tested positive as well.
Hang on a minute, Zoe. Your Honor, we believe that we will formulate a scenario through admissions that she did not protect Mr. Potter when she left treatment.
All right, hold on. I appreciate everybody wanting to jump the gun and put the cart before the horse, but I'm still trying to get it into the gate.
Right.
So I'm just telling you what you're charged with and what I'm told to which you're going to plead guilty. Then we will get to the description of what happens.
Thank you, Your Honor.
So if you plead guilty to counts 2 and 3, Ms. Davidson, you will not have a hearing of any kind if I accept that plea. You will be given up the right to have the prosecutor prove the allegations by preponderance of the evidence, the right to question and cross-examine any witnesses presented against you, the right to present witnesses, evidence, or testimony if you chose to do so, as well as the right to remain silent and not have that silence used against you. Do you understand that, Ms. Davidson?
Yes, Your Honor.
Additionally, you'll be resentenced on your original offenses for which you were convicted. Count 1 was a charge of attempted assault, resist, or obstruct a police officer. And count 2 was possession of the controlled substance methamphetamine. The first offense is punishable by up to a year and $1,000. And the second is punishable by up to 10 years and or $15,000. Do you understand that, Ms. Davidson?
Yes, Your Honor.
Now, also, for technical probation violations, the court is limited to a sliding scale of 15 days for 1, 30 days for 2, 45 days for 3, or no limitation if there are 4 or more, or there's a non-technical. Because there is a non-technical in this, the court would not be limited to that sliding scale. Mr. Potter, have there been prior probation violations?
Multiple, Your Honor.
And so we have already exceeded the 3 or 4 prior technicals, so no matter what, the court is not limited to that sliding scale. Okay. Now that I've told you what your rights are, the accusations, as well as the possible consequences, do you still wish to plead guilty?
Yes, Your Honor.
Has anyone made any promises, threats, or inducements to force you to plead guilty?
No, Your Honor.
All right, now knowing all that, as to counts 2 and 3, how do you plead?
Guilty, Your Honor.
Before the court accepts that plea, I must have you tell me what it is that you did that makes you guilty of that offense. Now, before you do so, I'm going to hereby take judicial notice of the terms and conditions of your probation. Those were signed by this court back on May 23rd of this year and acknowledged by you on May 28th, and they appear inside the file. All right, so tell me, on October 17th, was your contact or interaction with Mr. Anthony Couch?
Yes.
Well, no, what was it? Where were you? Tell me about it.
I ended up getting sick. I took a bus back to the bus station. My aunt picked me up. I went back to my grandpa and grandma's, and I hung out with Anthony Couch.
All right, and you knew that he was had a felony conviction and was absconding from parole. Is that correct?
Correct.
Now let's talk about this. Were you on the count 3? Were you ordered to treatment at Sacred Heart back on October 3rd?
Yes, Your Honor.
And did you report to Sacred Heart on that day?
I did.
And it looks like you left that treatment. What day did you leave treatment? Do you recall?
I left the treatment because I tested positive for COVID. And when I got back here to Wexford County, they tested me again, and it was the same thing, positive test. So, I mean, I didn't leave treatment on my own, and I wasn't kicked out of treatment for any reason. I was sick, and they told me either I was going to find a ride or they were going to get me a ride back to Cadillac, and they ended up getting me a ride back to Cadillac.
Now we're going to go to that part of the conversation everyone wanted to jump to earlier. Tell me, Mr. Potter, what happened? Is there something more to the story?
Your Honor, she did test positive. I spoke with Sacred Heart. She was given the option of going into solitary until room until she had a positive or a negative test, or she was given the opportunity to leave, which they are not a holding facility. They don't require you to stay. She could sign out at any time. She chose to leave on that date, never contacted our office to see what option. She was in lieu of jail. By amended order, she violated those.
So in other
They never
words,
gave me the option to stay there. They never gave me the option to stay there.
Hold on. Let me ask the question. So it looks like regardless, even if they had given her an option, they were options, and if she chose one of the options, that's not my concern. Now the concern here is that she was sent to the program, released early from jail, correct?
Correct.
In lieu of jail, and then sent to the program. And then when she left the program, where did she go?
My understanding is she got picked up by ARU, Your Honor. We didn't know she was released from it.
What's ARU?
I'm kind of recovery, was looking for the parole.
Okay. How long after she left the program was she?
I think it was the next morning, Your Honor.
Okay. And so, Ms. Davidson, you made a statement earlier that when you left, did you get a ride down to Cadillac or over from Cadillac?
I ended up taking Indian Trails. I went from Flint to Kalamazoo, from Kalamazoo to Big Rapids to from Grand Rapids to Big Rapids and back to Cadillac. And they provided me with bus tickets to get from Richmond back to Cadillac. They did not give me the option to stay in treatment, or else I would have, Your Honor. Like, I was doing really good there and everything.
Okay, hold on. Again, you took an option. I don't care if they offered it to you another option. You took the option. They gave you a
Right.
ride. You got back to Cadillac. When did you arrive at Cadillac?
I arrived in Cadillac. It was like 6:30, 7 o'clock when I arrived at the bus station in Cadillac.
PM or AM?
It was PM.
All right. And then when you arrived back to the bus station in Cadillac, did I understand you correctly to say that you went from there to your grandparents' home?
I went straight from the bus station to my grandparents, yes.
Okay. And then did you stay the night at your grandparents' home that day?
Yes, I did.
And then the next day, what happened?
It was like 5:30 in the morning. The cops drove by. It was Deputy Wedzig. He drove by and seen Anthony Couch standing outside working on his truck, and Anthony took off. I was in the house sleeping. They weren't even there for me. They were there for him.
Okay. And so then how did you get discovered?
I got discovered because Detective Edwards asked if I was there because I was supposed to be in treatment, and my grandfather said I was, and they came in and woke me up, and they asked me if I was supposed to be in treatment. I told them I was sick, got called a liar for it, and then he went outside and I think he contacted Brian, and Brian said to book me, and I mean that's just how the cookie crumbled from there.
I got it. Thank you. Mr. Potter, what were the instructions given to Miss Davidson when she went to the facility initially?
Your Honor, we ended up making sure the defendant was on a bus to go to that facility just because she had made arrangements to be late to that facility to see Mr. Couch originally. So we put her on a bus to go down there. She signed an order that stated that she was released to residential treatment at Sacred Heart on 10/8/24 at 9 a.m. Enroll and complete the enhanced outpatient after successful release from the treatment. Failure to comply with probation conditions or successful completion of treatment shall result in your arrest and return to custody for completion of the sentence. Balance of the jail days after were to be served on MDOC tether until the out date. So, Your Honor, I kind of see where this is a very short turnaround. I think where the defendant failed in this was that before she left the facility, she should have contacted because she was in lieu of jail. And instead of going back to her grandparents, she should have gone back to the jail.
Or contacted you and let her know she was on a bus heading back to Cadillac.
I thought Sacred Heart was going to do that.
Okay. All right. And I understand, Miss Davidson, based upon the officers' names that you used, your grandparents must live over in Missaukee County?
Yes.
All right, thank you. All right, Mr. Carnes, do you believe the defendant provided a factual basis?
Yes, Your
Or that we have had a factual basis?
Yes.
Mr. Harrison?
Yes, I agree.
Mr. Carnes, are you aware of any promises, threats, inducements that we have not yet discussed on the record?
No, Your Honor.
Same question, Mr. Harrison.
Nor am I, Judge.
And Mr. Carnes, do you believe the court's complies to the court rule 6.445 at this time?
Yes, Your Honor.
Mr. Harrison?
I concur.
All right. The court agrees and finds the defendant's pleas today to counts 2 and 3 are made freely, knowingly, and voluntarily. The court further finds that the information provided by the defendant, in addition to the judicial notice of the terms and conditions of probation, as well as the information provided by Mr. Potter, which, by the way, I will note that inside the file dated October 3rd is a petition and order for amendment of her order of probation, which I approved on that same day, had the language directing her to report to Sacred Heart, and also failure to comply with conditions of probation or successful completion shall result in arrest or return to jail to complete the sentence. I'll note that the defendant did not comply when she arrived back to Cadillac. Instead of staying here in Cadillac and going to the jail, she went past the jail to get over to Missaukee County, and therefore had a rendezvous with Mr. Couch, who was a felon. Therefore, she is found guilty of counts 2 and 3. All right, now the question becomes, are we able to proceed to sentencing? Mr. Potter, how about you?
I'm able, Your Honor.
Mr. Carnes?
I agree, Your Honor.
Mr. Harrison?
No argument here, Your Honor.
All right. So, Ms. Davidson, I now turn to you. You have the right to be physically present in the courtroom when a court issues a sentence. Because you are there in the jail, you can request us to do the sentencing, which means we'll not do it now, probably do it next week. I don't really know if we have much time left today. Or you can allow us to do it via Zoom. Are we able to do it via Zoom? Do you waive the right to be in
Yes, Your
person?
Honor.
The court finds that waiver is acceptable underneath the court rules allowing video conferencing. All right, Mr. Potter.
Your Honor, I know His Honor is very familiar with this case, and I'm not going to go through a ton of details. 0 to 9 guidelines. We were just before this court on 9/23/24 for probation violation sentencing that the court imposed a 240-day with credit for 103. Your Honor, as of today, the defendant has 127 days credit, 127. With it, Your Honor, our recommendation back in September was 270 days and revoke probation. Court gave her a chance with a lower sentence, continued the probation for the treatment. Your Honor, we've listened to multiple phone calls while she was in jail after that sentencing. The defendant continues to associate with known felons. The attitude is not that she wants to come out and complete a successful probation term when she's talking on these phone calls, making arrangements to see known felons. I think she has the desire to continue the life that she's been doing for the past, I don't know, 18, 19 years, however old she is. So I'm going to go right back to my recommendation, Your Honor, of just recommending this court discharge probation.
Before we do that, Potter. All right, it looks like back on May, she pled guilty to 5 probation violations.
Title was revoked at that time.
Title was revoked, and then there was another one in September where she had 1.
Yes, Your Honor.
And let me take a look. Back in the May violations, let's take a look. Didn't attend the EOP program. Failed to attend, looks like
One of
twice.
those was dismissed, Your Honor. I just want to make sure that.
Yeah, I think it was number 5.
Number 2 was dismissed, Your Honor.
Was it 2 or
And there
5?
was one that was no contest. I had 7
Oh, no
violations,
contest is 7.
6 that were actually.
Count 5 is the one that I have listed as being dismissed. Then we had failure to complete outpatient or residential treatment. Then we got to 7. There was a FTD, using without consent, a financial transaction device charge. Then the violation here back on September 18th for testing positive for methamphetamine. Now these. All right, thank you. It's your position, sir.
Thank you, Your Honor. I support the recommendation of Mr. Potter. I don't believe he mentioned that his last recommendation in September was 270 days
He
jail.
did.
Okay.
He did.
Clearly.
And I gave her 240, gave her continued chances on probation and continued rehab, and then I let her out early to send her to an inpatient program because she only spent, looks like 2 or 3 weeks before I let her out to go to jail, to go to the program.
And I completely respect the court for doing that, but clearly this is not working. I think that recommendation is appropriate. I support it.
Thank you. All right, Mr. Harrison.
Well, I may be the only one who has a slightly different perspective. I acknowledge that you look at the paperwork in this case and it clearly paints a picture of someone who's flipping the bird to probation. suggesting by, if not by her words, at least by her actions, that she is not going to comply. She is not going to be rehabilitated. I can tell you the actual person behind this scenario, one-on-one with me, is a little bit different in terms of her attitude. You can see by her demeanor, even in court today, that she is independent, strong-willed, and a little bit feisty. I do think those qualities will serve her well, however, in tackling what appears to be a substantial problem that she has with substance abuse and the people with whom she associates. I realize the comment provoked laughter, but that was, I mean, my point
Well,
was.
it actually came from friends of hers who are in.
Okay.
And Ms. Davidson
And Ms.
herself.
Davidson. As you might know, just from the way that I speak to and about her, I've gotten to know her rather well recently, and I know she has shown me a bit of insight that frankly surprised me a little bit when she said point blank to me, "I can't do this anymore. The next stop is prison." So she is fundamentally aware of the depth of her issues at this point in time. And she's shown some self-awareness to the extent that she knows the logical extension of the path she's on is a trip to Huron Valley. Now, I know I'm saying all of this in a vacuum against the great weight of the file, where she's demonstrated several violations of her probation, and quite frankly, those are impossible for me to simply brush under the rug. The court's not simply going to ignore them. I'm aware of that. I think we need to look at what happened here very narrowly. She was sick. She did have COVID. She was in quarantine when she eventually got back to the jail. I couldn't see her for a couple of days because I didn't want to get sick again. The facility, I'm aware that they're not a secure facility. I'm having trouble grasping the thought process at the facility. You take people that are at their most vulnerable state, possibly ever. In addition to that, she's sick with COVID, and their response is, well, we gave her the option to get on a bus and infect everybody in the state of Michigan on her way back home, and we provided the bus ticket. That does not absolve Ms. Davidson from the choice that she made, whether you want to call it a choice or an option, whatever, we get the point. However, it does show the perhaps lack of wherewithal she sometimes exhibits. Same direction, she's hanging out with someone she knows or has reason to know is illegal for her to be in contact with, and she does it anyway. Why would she do that? Either of those things. The problem is, until someone like Zoe gets all the way through a rehabilitation program and, in a sense, retrains her own brain to think a different way, she will fall back on her old habits unless she is able to get a nudge in the right direction. Here's what I think it breaks down to, Your Honor. She's aware that she's going back to jail. She's also got a plan that upon her completion of this sentence, revocation of her probation, which we frankly believe is inevitable, that she's going to change the direction of her life. I'm encouraged by the fact that she's thinking along those lines. This may be that nudge that she needs in that direction to give her a few months in jail, I suppose, at the end of the day, to her credit. And again, I understand the department's frustration. I don't expect them to devote any more of their resources to her, but I want you to know that at least there's that glimmer of recognition in her that she is going to make some changes in her life so she doesn't end up in prison or, frankly, dead. She's aware of that. Thank you.
Thank you. All right, Ms. Davidson, your turn to say something if you wish.
I'm set.
That's it?
I'm good. I don't have nothing to say.
Okay. All right. Yes, sir.
I just didn't hear what she said, Your Honor.
All right, thank you. All right, well. Miss Davidson presents a interesting personality. I know she's young. I know she is, as people chuckled about today. I think we used the word feisty, or confident, maybe. And I appreciate that. But I've also seen from that some rebelliousness and resistance. I recall this incidents with her here in the court where she has expressed herself in ways that I would generally say are unacceptable in a courtroom, not also disrespectful toward the court. I haven't always dealt with that in a stern way, trying to maybe give her a little bit of a talk to and see if it helps, but it generally doesn't. I gave her a very, very, very good offer in the beginning. She had 4 days of jail with 4 days of credit and was placed on probation and given opportunities for outpatient treatment at Catholic Human Services. And she largely blew that up. And she tended to blame some of the failures on Catholic Human Services, as I recall back then. And now this instance, actually, she got in trouble and picked up another criminal offense, as well as multiple violations for resistance toward the rehab. I gave her another jail sentence, only made her serve. So she went from 4 to 120. Then I went to 240 and then let her out to give her rehab. And then she left. All right, she was on COVID. She had COVID. I got it. I understand that. But you don't wait around and ask for forgiveness. You call the probation officer. It's very, very obvious. That probation officer is, for the lack of a better phrase and not demeaning the job, Mr. Potter, you're a babysitter. And you ask the babysitter, listen, this is where I'm out at. I just got out. Where do I go? Can I go over and spend the night with my friend who has got a felony warrant for being a absconder and hang out with grandma and grandpa and pass the jail? Or do I just wait for you guys to find me and then come get me? One is active and it shows a real intent to comply. That's not the choice she made. She ended up not complying. I don't think she has a serious intent. She has the right to and the responsibility to direct her own life. And maybe next time she is looking at prison. She's already got multiple probation violations here. And at the jail, I recognize that Catholic Human Services is there, and we provide money so they can have an actual office inside the jail. And I agree with one word that, sorry, I understand many of Mr. Harrison's words are valuable, but there was one that stuck out the most. I always like asking, can anybody figure out what the word was? I don't know what Mr. Harrison said, but I didn't know what's the right word. It's the word nudge. So the court will give Miss Davidson her nudge. Court preserves, has she made any payments and fines and costs?
Yes.
Oh, good.
She has made quite a few payments, actually.
Oh.
She has paid a total of $550.
Oh, that's pretty good then. That's about a third. Anyways, the court preserves the remaining fines and costs. The court terminates probation without improvement, and that is never a reward. I highlight for Miss Davidson, the more probation violations someone gets just means, yes, next time they could be looking at jail or prison, depending upon the nature of the offense. That's just the way the law works. And the court sentences the defendant to 365 days with 127 days of credit. Anything, Mr. Potter?
I'm sorry, I was talking to the prosecutor. Did you revoke probation?
I revoke probation.
Thank you.
That's unsuccessful. Mr. Carnes, anything else?
No, Your Honor.
Mr. Harrison?
Nothing further.
Ms. Davidson, you're going to get 2 forms of one document. You will place your initials on one copy, acknowledge the receipt to the other. The other document will tell you that is going to be the one that you keep. It tells you that you have the right to appeal the conviction and sentence in your case, and that is typically done by filing a claim of right to appeal. However, based upon the pleas in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to the district, you complete the bottom half of the copy of the document that you will be provided and return it within 42 days. If you choose not to appeal, it simply just goes in your copy of the document. Ms. Davidson, I know that it sounds like, and arguably I am being a hard-headed person, but it's not it. I see a young person who, like Mr. Harrison talked about, has some potential. I think you do, because of your competence, because of your individual nature. But you've got to straighten up this lifestyle. If you want to continue leading it, that is 100% your choice. If you continue to break the law and continue to go down the road of using drugs, that is 100% your choice. And if you keep getting caught and keep getting charged and keep getting convicted, if you get sent to jail or prison in the future, that is 100% your choice. That's it. Ms. Davidson, good luck to you. We are adjourned.
Thank you, Your Honor.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.